The honourable member for South Surrey White Rock.
Thank you, Mr. Speaker, and I appreciate the opportunity to rise and speak this evening on Bill C-7, an act to amend the Criminal Code respecting medical assistance in dying or MAID. The meaning and consequence of this bill should weigh heavily on all Canadian parliamentarians. Today, we are debating the competing interests of individual autonomy and the sanctity of human life, addressing the suffering of our loved ones, the dignity of the elderly and disabled, and the moral, legal, and ethical concerns that are inextricably tied to medically assisted death. We are setting out the rules, standards, and boundaries by which Canadian doctors and nurses can, at a patient's request, terminate life. This cannot be taken lightly, and it is not legislation that should be rushed. But that is the predicament that this Parliament finds itself in. In 2016, the Liberal government passed Bill C-14, legalizing MAID. Last year, in the case of Truchon versus Attorney General of Canada, the Quebec Superior Court ruled that it was unconstitutional to restrict the availability of MAID to individuals whose natural death is reasonably foreseeable. Contrary to the requests of my Conservative colleagues and many advocacy groups, the Attorney General, who bears the responsibility of upholding laws passed in Parliament, chose not to appeal the ruling in Truchon. It is difficult for me to understand how something as essential to life as one's departure from it is not important enough to this Liberal government to appeal. This is something that should have had both comment and decision from the Supreme Court of Canada. Because of the Liberal government's inaction, we are now working up against a December 18th Quebec court-imposed deadline to enact a legislative response for the whole country. Its declaration of constitutional invalidity expires on that date. I want to ensure my constituents in South Surrey White Rock and all Canadians that as a member of Parliament and a member of the Committee on Justice and Human Rights, I will stand up for their shared values and beliefs and work tirelessly to ensure the amendments proposed in Bill C-7 and their consequences are carefully studied and considered despite the impending December deadline. Turning now to the substance of Bill C-7, I'm concerned that the bill as written is too broad and lacks the safeguards necessary to protect Canada's most vulnerable populations. Let me be clear, the removal of the reasonably foreseeable standard will significantly increase the number of Canadians eligible for MAID. The breadth of qualifying conditions widens considerably under Bill C-7. For anyone who initially opposed MAID on slippery slope concerns, it appears we are now sliding down that proverbial hill. Will we eventually follow the Netherlands? Their lead, which recently ended up in their announced plans to offer MAID to children under 12. As a group of physicians recently put in a letter to Minister Lametti urging an appeal of the Truchon decision, Canada will have moved well beyond allowing an autonomous life-ending decision at the end of life into the realm of death on demand for almost any reason at any time. We know from Health Canada's annual report published in July that 2% of deaths in Canada in 2019 were medically assisted. How much higher would that number be under Bill C-7? How many Canadians would be eligible for MAID without the reasonably foreseeable requirement? Both questions must be answered. If this is in fact the direction that Parliament decides to take this legislation, we need more safeguards to protect the more vulnerable, not less. As written, Bill C-7 redefines who qualifies for the end-of-life procedure and strips away some of the protections put in place a mere 4 years ago. One such amendment is the elimination of the mandatory 10-day reflection period. Under the original legislation, unless an exception applied, an individual wishing to receive MAID had to wait a period of 10 days after submitting their signed request. In most instances, the waiting period makes sense. It ensures time for reflection before taking the irreversible action of ending one's life. We know from Quebec's annual end-of-life care reports that since 2015, over 300 patients in Quebec alone changed their mind after requesting medical assistance in dying. And in any event, exceptions already exist under the original law for those whose death is fast approaching and for people who will soon lose the capacity required to provide the necessary informed consent. Why then remove this 10-day reflection period? Bill C-7 also takes aim at another safeguard included in the previous laws, reducing the number of independent witnesses needed to sign and date the candidate's application for MAID down from 2 to 1. This amendment would now apply to the newly eligible class of persons who are not faced with reasonably foreseeable or imminent death. Contrary to statements made in this House by the member for Winnipeg North, this is a real concern for many. As a civil litigation lawyer, I've had my fair share of exposure to all sorts of legal documents requiring the signatures of independent witnesses to ensure both authenticity and true intent. Wills, divorces, financial disclosures, affidavits, mortgages, to name a few. To express your intentions in a will in BC, you must have 2 independent witnesses not named in that will to witness the authenticity of your signature and your intention at the time of signing. If these requirements are there to safeguard your intentions regarding possessions, shouldn't they also be there to safeguard your intentions regarding method and timing of your death? It should be noted Bill C-7 does include a 90-day assessment period and directive that applicants be informed of available alternative treatments. But will these safeguards sufficiently protect our most vulnerable populations? When does the 90-day period begin? Is it recorded? Another piece of the bill that I have difficulty with is that it allows patients who may lose capacity before the end-of-life procedure is performed to give their final consent in advance. This troubles me for the same reason discussed before with respect to the 10-day waiting period. As we have seen, people do change their minds. In recent weeks, we have heard from many representative groups who have expressed concern about the decision in Truchon. The Council of Canadians with Disabilities, Canadian Mental Health Association, the Arch Disability Law Centre, and others have articulated the concern that making individuals with disabilities who aren't facing imminent death eligible for MAID would be harmful to the disabled community at large, affirming the untrue stereotype that a life with disabilities is not worth living. We must pause to reflect on that. Those who are passionate advocates for Canadians with disabilities are very concerned about the direction these court and policy decisions are taking us, and yet the Liberal government moves forward. There still exists the legal concept of undue influence. Who are most susceptible to undue influence and coercion? The vulnerable. We have also heard from hundreds of physicians who share a concern that some patients have chosen the path of MAID due to the suffering caused by a lack of proper supports. What is the tragic example from BC where a father suffering from Lou Gehrig's disease chose to undergo the end-of-life procedure because he didn't receive the support and resources he so desperately needed. This government is not listening to the heartbreaking stories of these ALS sufferers and their cries for fast-tracking of life-lengthening and life-sustaining hopeful therapies that we can't get in Canada. Is this government giving those sufferers and Canadians true options? We need compassion. Yes. But compassion takes many forms. Hospices are not readily available to all Canadians as an alternative. A good friend of mine died a couple of years ago now of inoperable brain cancer. He was a doctor, and in his case, he very carefully weighed MAID as opposed to living in hospice. He chose hospice because it extended his life for 5 months that he could spend with his family, and they were okay with his deterioration because they loved him and wanted to support him and be with him, but he had that true option. If we're going to expand this legislation, the government should equally ensure robust support for the vulnerable, hospice care, and hopeful therapies that should be available. Everyone matters. Finally, I'd just like to reflect on the healthcare professionals who are asked to implement this proposed law. We're now celebrating our doctors and nurses for their tireless efforts to keep our country healthy and safe. We should also ensure that they have the ability to decide whether this is compatible with their will or beliefs and not mistreated for any refusal to administer it. To conclude, I've heard from constituents in my riding who are on both sides of this argument. I ask my colleagues to really take the necessary time to study this bill, reflect on these proposed amendments, especially as they affect the most vulnerable. We must be compassionate, but also we must respect human life. Thank you.